So imagine being sent to a maximum security prison for nearly 2 years.
Right, which is just a terrifying thought right off the bat.
Yeah, exactly. And your crime. Quietly clicking retweet like less than 100 times on a VPN over the course of 3 years.
Less than 100 times. I mean, it's almost nothing.
Right. Now imagine taking the official court documents that put you in that prison cell, feeding them into 6 of the world's most powerful AI supercomputers, and just watching the machines systematically prove that your human judges broke the laws of mathematics, logic, and their own legal code to lock you up.
It's a really profound stress test.
Yeah.
You know, we're looking at this wild scenario where human legal reasoning, with all its messy political context and like shifting definitions, is forced into a direct collision with just cold, hard algorithmic objectivity.
It really is. But before we dig into the mechanics of how these 6 AI models, so we're talking Grok, Gemini, ChatGPT, Copilot, DeepSeek, and Quinn, before we see how they audited this case, it's vital to establish the ground rules for our discussion today.
Yeah, absolutely. We need to be clear about what we are doing here.
Exactly, because the source material we're examining for this deep dive involves a real-world criminal prosecution within the Chinese judicial system. And since this involves state politics and highly charged legal actions, I want to make it explicitly clear to you, the listener, that neither of us here are endorsing any political viewpoints, left-wing or right-wing.
No, not at all.
Right. We are strictly and impartially reporting the contents of the case and the subsequent analyses produced by the artificial intelligence models exactly as they are detailed in the source documents.
Exactly. We are acting purely as architects, examining a blueprint. We're looking at the structural integrity of the legal arguments and how the language models parse that structure, totally independent of the politics.
Okay, let's unpack this. The blueprint in question belongs to the case of Dr. Chen Jingyuan.
Right.
And to grasp how the AI models just tore these legal documents down to the studs, we have to look at the primary sources they were fed.
So they analyzed the Xishan District Prosecutor's indictment, the first instance judgment from the Xishan District Court, the second instance ruling from the Kunming Intermediate Court, and a rather extraordinary defense letter.
Yeah, the blood letter, right, that Dr. Chen wrote from his prison cell.
Yes. And Dr. Chen is, well, he's not your average defendant. He actually holds a PhD in physics.
Oh, wow.
Yeah, he specializes in complex systems.
Yeah.
And he was arrested in Kunming in September 2022 and charged with picking quarrels and provoking trouble.
Which, I mean, that is an incredibly broad charge, but the physical reality of his actual provocation is just staggering.
It really is.
Between 2019 and 2022, he used a virtual private network to retweet fewer than 100 posts on Twitter. Wait, less than 100 retweets over 3 years. That's like getting a speeding ticket for inching forward in a drive-thru. We are talking about a fraction of a retweet per week.
And for that microscopic digital footprint, he received a sentence of 1 year and 8 months.
Unbelievable. Yeah.
So when the 6 language models were asked to audit the legal documents justifying this sentence, they reached what the sources call a digital rule of law consensus.
A consensus, like all of them agreed.
Every single one. They all independently concluded that the prosecution suffered from a total systemic failure. They found a complete lack of substantive evidence required by law.
It's fascinating. You know, instead of a visual matrix of cascading green code, I picture this more like a software compiler debugging a broken piece of code.
Oh, that's a great analogy.
Yeah, because the AI isn't just reading the text, right? It's looking for logical loops that don't close. So when the human court inputs command, the AI flags it as a syntax error because the variables just don't match up.
That is a highly accurate way to frame it. The models essentially mapped out how the foundational requirements of the law were completely bypassed.
How so?
Well, for instance, to be found guilty of this specific crime, the state's own statute requires that a person knowingly spread false information.
Right. Intent is the core variable there.
Exactly. But the AIs scanned the court documents and found literally zero proof of Dr. Chen's actual intent. There was no confession of malicious planning, no intercepted messages outlining some grand disinformation campaign.
So the court just had to synthesize intent out of thin air.
Basically, yes. And the way they did it is mind-boggling.
Here's where it gets really interesting, because I was reading this part of the source. The judgment argued that because Dr. Chen has a PhD and a high level of education, he, quote, should have been able to distinguish right from wrong.
Right. and therefore he must have acted intentionally.
I mean, that completely ignores the value of positive personality traits. That's like saying a brilliant scientist who asks questions must be a malicious liar. They took his scholarly skepticism, which is a positive personality trait essential for a PhD, and weaponized it as proof of criminal guilt.
What's fascinating here is how the language models, particularly Gemini and DeepSeek, flag this immediately as a massive legal violation.
What do they call it?
In legal terms, it's known as objective imputation based on identity.
Objective imputation.
Yeah. It basically means you are pronounced guilty because of who you are, not what you actually intended. The AIs penalize the court heavily for conflating two entirely different concepts.
Which are?
Should have known versus actually knew.
Oh, right, because should have known is just like a moral or cognitive expectation. It's an assumption a judge is making. But actually knew is a verified psychological state. You have to prove that.
Precisely. DeepSeek pointed out the massive logical fallacy here. Using someone's educational background to presume their psychological state at a specific moment in time, it replaces the heavy, legally required burden of factual proof with a convenient assumption.
Wow.
Yeah. From an algorithmic perspective, the variable of intent was never satisfied. The logic branch just hangs there, completely broken.
Okay, so if the intent argument collapses under algorithmic scrutiny, the next logical step is to examine the payload itself. Like, what exactly was in these less than 100 retweets that the prosecution labeled as dangerous, false information?
Well, according to the documents, the content was incredibly varied. Dr. Chen retweeted a cartoon of an umbrella girl, a photograph of a candlelight vigil, some historical data regarding Mao Zedong's writings, and official posts directly from the U.S. Embassy account.
The AI model, Quen, brought in a philosophical critique here that I just found brilliant. It called the prosecution's argument a category mistake.
Yes, the category mistake.
Because the legal statute requires that the defendant spread falsifiable facts. The classic example being, shouting fire in a crowded theater when there is no fire. You can physically verify the presence or absence of combustion. It's binary.
Right. It's either true or it's false.
Yeah.
But an emotional expression like a photograph of a vigil or a piece of political art like an umbrella girl cartoon, by definition, these cannot be proven true or false in a factual, physical sense.
Yeah, they're subjective.
Exactly. They simply do not belong to the category of things that can be fact-checked. Quen noted that forcing art and opinion into the rigid framework of factual verification is a profound systemic error.
But wait, I want to push back on that a little bit because we are dealing with the sovereign legal system. If the state, within its own borders, writes the laws and deems a specific cartoon to be insulting to the government, doesn't the state possess the authority to define that insult as illegal?
The state absolutely possesses the authority to draft its laws, yes. But the AI models are auditing the internal consistency of how those laws are applied. This is where we have to understand how large language models parse semantics.
Right, how they process language.
Exactly.
Yeah.
An LLM predicts and maps language based on strict linguistic rules and massive semantic relationships. Even within the jurisdiction's own statutory language, the concept of insulting maps to an entirely different semantic cluster than factually false.
Oh, I see. So even if the state decides they don't like the cartoon, they can't magically transform an insult into a rumor without literally breaking their own dictionary.
That is exactly it. ChatGPT and DeepSeek both pointed out that the prosecution was forcibly transforming ideological disagreement into the strict statutory definition of a rumor.
Which is a huge leap.
It's a gross, unwritten expansion of criminal law. An algorithm flags this because the semantic leap from unflattering art to falsifiable fact violates the foundational linguistic rules the AI operates on, as well as the written law itself.
And furthermore, the AI models highlighted a mechanical distinction between fabricating a rumor and merely forwarding a post. I mean, Dr. Chen didn't draw the cartoon, right?
Right, didn't.
And he didn't draft the embassy statements. He literally just click retweet. But the statute specifically targets the fabrication of false information.
Right, conflating the creation of a falsehood with the passive forwarding of a digital artifact is another glaring syntax error in the legal logic. The court essentially erased the distinction between the author and the audience.
Okay, so the court failed to prove intent, and the content itself didn't even meet the legal definition of falsifiable facts.
Correct.
But to actually be convicted of picking quarrels and provoking trouble, the law demands a physical consequence, right? The actions must cause serious public disorder.
Yes, actual offline consequences. And keeping in mind that Dr. Chen had fewer than 100 followers on Twitter, his post generated almost zero engagement.
Which makes sense.
Yeah. This is where Copilot's analysis is particularly striking. Copilot evaluated the indictment's claim that Dr. Chen caused serious public disorder and categorized it as a hollow state proposition.
A hollow state. Which essentially means the court wrote a sentence that is grammatically perfect, right? Like, the defendant caused serious public disorder.
Yes.
But it's legally and physically empty. There is absolutely no data inside the shell. No riots, no offline chaos, no crashed servers, no police reports of public disturbances linked to his account.
Nothing at all.
Just a legally required phrase typed onto a piece of paper to fulfill the statute's requirement.
It was an assertion operating in a complete vacuum. And if we connect this to the bigger picture, this brings us to the most remarkable aspect of the entire case. Dr. Chen's scientific defense from his prison cell.
Oh, I love this part.
Yeah, he didn't formulate his appeal like a traditional lawyer's parsing precedent. He argued it like a physics PhD analyzing a network failure.
He used his background in complex systems to mathematically prove his innocence. The sources show he specifically cited Gödel's incompleteness theorem and the CAP theorem from computer science. I mean, this is where the intersection of law and science gets just incredible.
It really does. It requires us to understand how these theories actually map onto a social media network. Let's look at the CAP theorem first.
Yeah, explain that one.
So in computer science, the CAP theorem states that a distributed data store can only simultaneously provide 2 out of 3 guarantees: consistency, availability, and partition tolerance.
Okay, and Twitter is a massive distributed system. Millions of nodes all over the world. Dr. Chen's argument was that his account is a tiny edge node, right? A microscopic point sitting on the very fringes of this massive network.
Right. And applying the CAP theorem, Dr. Chen demonstrated that a single edge node acting independently cannot force the entire system into a state of inconsistency. It can't trigger an avalanche effect that takes down the network's availability.
Because it's just too small.
Exactly. Unless there is a massive network partition, which there wasn't. His isolated retweets mathematically cannot cause the macroscopic chaos the court accused him of. It is literally physically impossible for his inputs to generate serious public disorder.
Man, that is brilliant. And then he layered Gödel's incompleteness theorem on top of that.
He did.
Because Gödel proved that in any complex logical system, there are statements that are true but unprovable within the rules of that system. A closed system cannot prove its own consistency.
Right, and Dr. Chen used this to argue that the legal system's attempt to draw a direct causal line from a microscopic isolated action, just one retweet, to a macroscopic systemic collapse of public order is logically unprovable within the system's own rules. You simply cannot logically prove that an isolated node caused the whole system to fail when the system itself remained entirely stable.
It's like being charged with trying to empty the ocean with a teaspoon and defending yourself by explaining the physics of fluid dynamics and volumetric displacement to prove you knew it was impossible from the very beginning.
That is a perfect analogy, and that is the crucial legal pivot. Gemini specifically praised this defense as a profound, cross-disciplinary legal argument.
Did it really?
Yes, because
Yeah.
by using theoretical physics and computer science to mathematically prove that his actions couldn't possibly cause systemic chaos, Dr. Chen established that he knew his actions were harmless.
Right, which completely vaporizes the prosecution's claim that he had the subjective intent to cause public disorder. Because if you know for a mathematical fact that your action has zero impact, you cannot harbor the intent to cause a massive impact.
Exactly. The AI recognized that his scientific defense wasn't just some theoretical exercise. It was a devastating dismantling of the mental state required for the crime.
So having walked through all these specific failures, the fabricated intent, the semantic category mistakes, the mathematically impossible public disorder, it's fascinating to see how the different AI models actually process this data to reach their verdicts.
It really is, because they didn't all just spit out the same generic summary.
Right, they have different architectural DNA. I imagine Quen, being a highly practical and data-driven model, just looked at the raw legal logic and graded it like a math test.
That's exactly what it did. Quen took a strict quantitative approach. It evaluated the logical integrity of the arguments, and it gave the official legal documents a dismal score of 2.4 out of 10.
Wow, 2.4 out of 10 for a supreme legal document.
Yeah, for systemic violations of basic evidentiary principles.
And ChatGPT is built for step-by-step reasoning, right?
Yes. It provided a systematic chain analysis, showing precisely how the justice system derailed at every sequential phase, from the initial police action to the prosecutor's flawed indictment, right through to the appellate court's rubber stamp.
But Grok is different. Grok's underlying programming leans a bit more toward anti-censorship and rebellion. I bet its audit looked entirely different, focusing heavily on the macro human rights angle.
You're spot on. Grok completely bypassed the micro-level procedural errors and evaluated the case against the backdrop of human civilization itself.
Really?
Yeah, it studied the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Grok's verdict was that the court's legal logic wasn't just flawed. It called it an affront to the foundational principles of modern civilizational rights.
And what about DeepSeek?
DeepSeek took a highly pragmatic, policy-oriented approach. It pointed out a glaring systemic irony.
Which was?
That the local courts, by stretching the statute so far beyond its written limits, were actually deviating from the central government's own stated rule of law policies. DeepSeek highlighted the massive technical gap between high-level legislative intent and ground-level judicial enforcement.
You know, it's easy to look at this case as an isolated, tragic incident in Kunming, but the underlying threat here feels like something that could creep into any digitized legal system. It exposes the terrifying reality of pocket crimes.
Yes, pocket crimes are a very well-known phenomenon in legal history.
Explain what that means for the listener.
So they occur when a statute is intentionally written or subsequently interpreted so vaguely that it becomes a pocket to catch almost anything the authorities find undesirable. Historically, they're used as a catch-all mechanism for local authorities to maintain control when specific, well-defined laws don't apply to the behavior they want to stop.
So when laws are intentionally vague, they cease to be protective rules and just become tools of arbitrary power. If picking quarrels can mean mathematically harmless retweets of a cartoon, then the law basically means whatever the judge wants it to mean on any given Tuesday.
And that leads directly to the erosion of procedural justice, which the AI models also flagged heavily. The documents reveal that Dr. Chen's trial was held in secret without a valid, stated legal reason.
That's terrifying.
And furthermore, the appellate court outright refused to hold a hearing. They opted instead to simply rubber stamp the first instance decision.
It's a complete inversion of the justice system. The burden of proof was entirely shifted. Instead of the state bearing the heavy burden of proving Dr. Chen caused measurable harm, the court essentially demanded that he mathematically prove he didn't.
Exactly.
And even when he did exactly that with the CAP theorem, it didn't matter. When procedural justice breaks down, the actual physical truth of the facts just stops mattering.
This raises an important question, and it's the sobering reality that all 6 AI models uncovered. Working entirely independently of one another, processing thousands of words of official human legal documents, these algorithms found the exact same logical, procedural, and evidentiary black holes.
Yeah.
They saw right through the hollow state propositions. They identified the semantic category mistakes. They recognized the objective imputation.
So what does this all mean? They acted as the ultimate flawless diagnostic tools. The X-ray machine worked perfectly. It highlighted every single fracture in the legal logic in bright red, but the doctor refused to look at the screen.
And that is the crucial limitation of algorithmic objectivity. The AIs could perfectly dissect the broken logic. They could grade it a 2.4 out of 10. They could cite international law and computer science theorems. But they could not free Dr. Chen.
Right.
He still served his 1 year and 8 months in a cell. Logic, mathematics, and even written law, unfortunately, do not always align with human power.
Which leaves you with a final thought to mull over today. We are entering an era where artificial intelligence can act as an instant, objective, and multidimensional auditor of complex, high-stakes human systems. It can spot the biases, the semantic tricks, and the logical fallacies that humans either miss or intentionally ignore to serve their own ends.
It's already happening.
Right. So could we eventually see a world where an AI audit is a mandatory procedural requirement? A system where a language model must mathematically fact-check the logical integrity of every judge's ruling before a person can be deprived of their liberty and sent to prison.
That's a huge hypothetical.
It is. And if we do reach that point, what happens when the cold, hard, inescapable math of algorithmic objectivity is forced into a direct, unyielding confrontation with the messy, protective reality of human judicial power?